Appeal Division 1 is now in session.
Please be seated.
Oops. Sorry about that.
We're just making sure that you were awake. We are here for oral argument in 1 CA CV19 0218. Parmeley versus Carr. The proceedings are being audio and video recorded, so both sides are responsible for watching the clock and determining, making sure that your argument is presented in a timely fashion. Appellant's counsel is advised that if you want to reserve any time, it's up to you to make sure that you do that. We have read the briefs. We have discussed this case this morning in conference. Counsel, you may proceed.
Good morning, Your Honors. May it please the Court. I'm Kirsten Copeland, arguing on behalf of appellants Jennifer Carr and Kathleen Pascoe. I'm going to try to refer to the parties by their last names, but we have a lot of similarity in both last names and first names, so if I call anyone by their first name, I certainly don't mean any disrespect. It's for clarity purposes. Ms. Parmeley, in this case, who is the surviving spouse, her claim to all or a portion of the life insurance proceeds at issue here rests upon really two separate and alternative claims, really two alternative legal theories. The first one, which is outlined in Section 1, which tracks through all the briefs, all of the sections, section numbering matches up through all the briefs, is whether or not the decedent violated the preliminary injunction issued pursuant to ARS 25315 in the subsequently dismissed dissolution proceeding. The other alternative legal theory is that by changing beneficiary designations on his life insurance policy during the pendency of that action, that the decedent effectively devolved a portion of Ms. Parmeley's share of the community to his daughters. And two issues really fall under that second legal theory. One is whether or not the residence and the pension plan should have been counted for purposes of evaluating whether Ms. Parmeley did actually receive her community share. And the other piece of that is whether or not Arizona law permits a surviving spouse to claim all or a portion of the decedent's share of their community interest on grounds of marital waste.
Counsel, before you
Sure.
go any further, just a factual question. Did Mr. Parmeley have a will? Or
He did. To our knowledge, he did not, Your Honor.
So he died intestate?
He died intestate, correct.
So under Arizona intestate law, all his entire interest in the community would have passed to her unless specifically designated otherwise, correct?
No, Your Honor, because he had children from prior relationships. He had children who were not also children of Ms. Parmeley.
And how does that divvied up?
So that gets divvied up by his share of the community would devolve to his children from prior relationships, and half of his separate property would also go to them. Half of his separate property would go to his surviving spouse. So essentially, half of his estate would go to his surviving spouse, and the other half would go to his children from other relationships to be divided equally among them.
Okay. And did you make a claim in the Superior Court for a marital lien on the residence?
No, Your Honor. And I'm not sure under what proceeding that would have necessarily occurred without opening a separate probate.
I'm trying to understand how the house passes. Let's say the house had been in Ms. Parmeley's name only. It were her sole property from the start. Presumably the community might have a lien against it if community funds had been spent to either improve or to pay the mortgage. And I guess
that would be correct. I'm sorry, I didn't mean to interrupt. I mean, that is correct in the sense that in a probate proceeding, one who would have a claim to an intestate share of a decedent's community would have to bring that in a probate proceeding, and it would be analogous to at least to a lien against. And it's a little confusing because I think you referenced it as her separate property
Well,
and
I'm
just a
just saying
community lien.
since the property here was held in joint tenancy, which means that it effectively passes directly to her on death. So, but assuming it had been separate property, the estate presumably would have had a lien, but that's not something that was developed here or argued?
No, because that proceeding would have had to have occurred in the context of a probate, and it would also have had to have been, because that would have been an issue of essentially a debt that was owed to the decedent prior to death. That would have also had to have been.
You're saying that could not have been brought in this proceeding? It seems like all of the assets are being treated. She was initially appointed to essentially take care of his estate, and then the daughters are saying, no, she has a conflict.
Well, can I back up, because
Sure.
maybe I can provide a little bit of overall support on that. I think your question is a complicated one, and on the other hand, I think it's superseded by the analysis that's put forth in the Gagey, and I think that's the pronunciation. If it's not, I don't know what it is, but the Gaethje case, that's the analysis in Gage, is that when you're dealing with division of both probate and non-probate assets upon the death of an intestate, well, even not an intestate, any death of a decedent, whether there's a will or not, the decedent has no power to alienate the community interest of the surviving spouse. And so whether or not there's a community lien or what the classification of property is in terms of whether it's community, whether it's separate, whether it's jointly held, those sorts of things all get subsumed into that analysis and simply determining whether or not the surviving spouse actually received the equivalent of the surviving spouse's community share. So to the extent a community lien exists, as to the house for improvements and things like that, I think that would get subsumed into the analysis of Gage and its progeny.
But isn't it more than that? Because a community lien is more than just improvements. Community lien is paying down the mortgage with community funds.
Sure.
And it's in the appreciation value of a home. Community liens can be quite sizable. And in this case, if we view this property as being joint tenancy and it passes to her upon his death, then it's her asset and it's out of the community equation, but for if the community had a lien on the property, isn't it?
I don't think so, Your Honor, because number one, I think, and it is addressed in our briefs, there is an issue, or at least the trial court appeared to conclude, based on holding the property as joint tenants with right of survivorship as opposed to community property with right of survivorship, that property was held in derogation of community property principles, that it was indeed separate property. The trial court never actually said that, but did make a finding that the house was not community property. Our position is that's an incorrect finding, because by itself, holding property in joint tenancy, particularly in the facts of this case, where the reason it was held in joint tenancy is because Mr. Parmeley, Mrs. Parmeley, and Mrs. Parmeley's mother all acquired title to the house at the same time. They could not hold that property as community property with right of survivorship.
But once she died, they could have transferred it into a community property with right of survivorship kind of arrangement, couldn't they? When Mom died.
Correct. They would have had to take separate affirmative steps, though, to do that.
And so don't we just simply look to the title, joint tenants with right of survivorship? Upon your death, your interest in the property extinguishes and vests in the other joint tenants.
Well, yes, that's true, except that doesn't eliminate the residents from consideration of whether or not that provision, like any other separate provision, like for example, a testamentary disposition of separate property to a surviving spouse, All of those things still get considered in finding out whether or not the spouse received her share of the community. Although our argument is that Title 25 principles in terms of equitable division of property don't apply, the definition of community versus separate property is incorporated into Title 14. And so making it whether or not the house actually was community property, we argue that it was. But even if it was not, it was still subject to division as separate property. She nevertheless received the decedent's separate share of his interest in that residence.
Well, hold on. Once he died, he had no share in a joint tenancy arrangement. Once a decedent dies in a joint tenancy, his interest in the property is extinguished, isn't it?
I'm unaware of any Arizona authority that provides for that.
Then
Your
why
Honor.
do we have any kind of right of survivorship kind of language if it doesn't survive, if it does survive death? That doesn't make any sense to me.
It is an estate planning mechanism, right? So the reason for holding it is exactly that, so that it can pass without the necessity of opening a probate and conveying title.
Title passes automatically upon the death of one of the joint tenants to the other. Now, if there's an equitable remedy, that's one thing. But all your interest in that property is extinguished once you die.
I guess I'm not understanding if his interest is extinguished. We'll just say for purposes of this argument that in fact is a correct legal statement. I'm not entirely sure it is, but for the purposes of the issues here, it doesn't change the fact that she succeeded to that interest. She got the whole thing.
But I don't think to me, where I'm struggling is trying to understand why it would be different than if it were titled specifically in her name, even though it were purchased with community funds. She's not getting anybody's interest. She owns the property. We wouldn't be going through any kind of question about who owns this. The only thing that the estate has is a lien kind of under Drehos. Let's say it had been it was her separate property that we would go through and calculate is the estate, is the community entitled to some sort of lien against the property. But but we're not saying it's a community asset. It's her asset. The question is just, does the community have a lien? And that's what I'm wondering. Was that developed to know how much the property appreciated, how much mortgage payments were made from community funds?
I guess my issue is that the community lien is only an issue because of the dissolution proceeding. The dissolution proceeding automatically abated on the death of Frank.
But you're saying
Parmeley.
title changes when you file a dissolution proceeding?
No, it's the community lien on that property only. It doesn't transform the nature of the property. It is nevertheless either community or separate or however it's characterized. The lien does not change the nature of the property. The community lien only applies in the event of allocation in the dissolution proceeding of equitably dividing up property and deciding what is equitable, and not necessarily equal, but equitable for the two parties to have. That's not the case here because the dissolution proceeding automatically abated on death and shifted the issue into Title 14. I think we're at a little bit of an impasse here.
If we were to think hypothetically, let's just say that, and Miss Parmeley, we've been calling her Kathy, owned that as her separate property. Coming into this.
The whole house.
The whole house.
Okay.
How would that change your analysis?
It would change the analysis because it is her separate property and has no bearing. In other words, there is no testamentary or non-testamentary disposition. He has no interest in it, right? So there is nothing, it would not in that case be counted because it's not her community property. The fact that she received it doesn't change what she received in terms of her interest in the community.
Okay, and let's say community funds were expended on maintenance of that piece of separate property. Does that have any bearing on this?
Not just maintenance, but on items that
Mortgage
improve the
payments,
value
yeah.
and mortgage payments. Doesn't the community have a lien?
I am unaware of any probate type case, not just a testacy or intestacy proceeding, but I'm unaware of any particular probate case involving non-probate transfers of any kind under which there was a marital lien that was claimed successfully under those circumstances. So I don't know that in order for children of a prior relationship to succeed to any interest in the property.
So if my contention is correct, that husband Frank's interest in the property evaporated upon his death through the right of survivorship, would your clients have any claim to that separate property now owned by Kathy Parmeley?
But I think that's a different thing because,
I'm saying assume
right,
that my interpretation is correct, that right of survivorship means your right to the property is extinguished upon your death, and it automatically vests in your co-tenants. Would your clients have any right?
Yes.
And what would that be?
so it's the right, so what we're talking about here is the validity of the beneficiary designation on a life insurance policy. It's not that my clients have an interest in the house in particular. The issue is whether what at the end of the day Ms. Parmeley received through any sort of disposition, whether it was, and these are itemized in the Gagey and progeny cases, it's itemized in those cases where any sort of a disposition, whether it's through joint tenancy, whether it's non-probate transfers, whether it's a testamentary disposition, if at the end of the day the value of the assets that Ms. Parmeley actually received are equivalent to what her community share would have been, that she cannot then invade a non-testamentary disposition that's given to others. That's the issue. It's not so much that the claimants have a right to the house. It's that evaluating the fairness and whether or not the other dispositions, in this case the disposition by beneficiary change on the life insurance policy, had the effect of depriving Kathleen Parmeley of her community share. Did I get there?
I hear what you're saying. I'm not sure I agree with you, but I understand your issue and your argument.
Right. So backing up a little bit, if I understand your premise, I think your premise goes to how do you even calculate to begin with what the value of the community is, right?
Not exactly.
Because that calculation has to occur.
You're 3 steps down. I'm
Right.
talking about title to property, and let's just harken back to law school and real property. When we talk about tenants in common with right of survivorship, there are certain things that go along with that, and it's kind of separate from any kind of probate issue. What I've asked you is if she owned it separately, would your clients have an interest in it? And your answer
is no, Your Honor.
And
And that is because it's separate. We're dealing only in this case with the community.
But you're saying there wouldn't be a community lien. Would the community lien be helpful to your clients? Separate property.
So it's sort of, in order to do that, you sort of flip everything on its head, right? Because if there's a community lien, now it's almost like an affirmative defense, I guess, right? That my clients are entitled to the entirety of the insurance proceeds with the beneficiary designation on the life insurance proceeds, and that Kathleen Parmeley didn't get her share of the community because there was a community lien reduces her share. I mean,
I think it goes to when you're trying to determine what is the community assets involved.
Mm-hmm.
If there was a community lien on the residence, that would be something that would have to be factored into what is the total value of the community assets. So it may play out to, if there was $100,000 community lien on this, 50,000 of it would be his and 50,000 would be hers. Right. When you're talking about when we're splitting up the assets and what he can designate on the life insurance proceeds.
Right, but at the end of the day, I'll go back to the argument, and maybe and in our briefing, I indicated that I didn't think it matters. Clearly, the panel disagrees with me, right? But I didn't think it mattered whether you characterize the house as community property or separate property.
Well, but and sorry to interrupt,
right,
but,
sure.
but let's say the entire house was a gift from grandmother. Are you saying it's necessarily a community, and it's held in joint tenancy at this point? Are you saying it's necessarily a community asset? They're both entitled to 50% of it when it was purchased by grandmother, put in I guess it's put in joint tenancy. It's necessarily a community asset, you're saying at
Is
that point?
acquired it's the presumption is that all property acquired during marriage is community property. And to go to your point, I think, which is a little bit of a nuance, is that, let's just assume for the sake of argument that Kathleen Parmeley's mom was the one who paid for it. She nevertheless allowed everybody to be put on title, both her son-in-law and her daughter, which is pretty clear evidence of a gift to the community, right? Because they both then acquired, he's on the title, it's not held separately at that point by Kathleen Parmeley. So
But I'm having a hard time getting over if you're willing to say that title does pass the second he dies. There's now, title has gone to the surviving spouse, or the surviving joint tenant.
And I think I got to say, whether or not title, this always happens. Let's just stay away from real property for a moment. If you're dealing with an annuity, or you're dealing with a bank account that has a POD or a TOD designation or some other beneficiary designation, title automatically passes. That's the nature of the property. That doesn't necessarily change it from community to now separate property. It's in terms of a probate proceeding, like for example, a personal representative under the probate statutes has the authority to invade non-probate transfers in order to pay a surviving spouse their share of statutory allowances if there are insufficient other probate assets to pay that. So the analysis doesn't stop with the transfer of title. Title in this case, just like in family law, the title to the property is not the be-all and end-all of evaluation of property. It has to be evaluated separately. Just how title is held isn't the end of the analysis.
All right, thank you, Ms. Copeland. Your time has expired. Mr. Briggs.
Thank you and good morning. May it please the court, Your Honor. My name is Paul Briggs. Along with Melvin Sternberg, we represent Kathy Parmeley. And if I may, just to kind of cut to the chase, answer the questions. No, the claim was not developed of a community lien at trial. Yes, I believe it could have been. And the right of the joint tenant does extinguish upon death. And we cited the Toth case and the Collier case that clearly holds that is separate property.
So distinguish for me, if it vests on death in the real property context, why didn't title vest in Jennifer for the bank account and the girls for the life insurance, if that's the case?
Because real property is treated differently than bank accounts. That's the simple explanation, and that's the way it's been treated under the law. So in this situation, a community lien for payments to the mortgage, improvements, all those kinds of things that oftentimes are litigated in dissolution cases, we believe could have been raised and litigated in this case.
Wasn't it raised? Wasn't it at least alleged that that mortgage, was it disputed that mortgage payments were made from community funds?
There is a dispute over that because I believe there was testimony that the mother, Kathy's mother, made payments on the mortgage for a significant period of time. So that would have been.
But doesn't that just go to the value of the lien versus?
Exactly. That would have been a disputed issue on the value of the community lien. But to answer your question directly, there was a dispute over whether community funds were used to pay the mortgage or not.
But there's no dispute that at least some community funds were used.
I believe some, yeah, clearly after the mother's death, at least some funds.
But there was no, you're saying it was not developed to determine if there was appreciation in value in the property attributable to the community contributions?
Correct. It was not raised. I don't believe it was raised formally, and I know it wasn't raised formally in any of the pleadings, and I don't think it was raised informally, and certainly was not litigated at trial or any type of evidence at trial. But I believe it could have been because that is consistent with our theory that when we are trying to determine the community assets available to make sure our client gets at least her one half, that could be part of the determination, just like we asserted that community waste would be part of the determination of that net value. So our position simply is that when the court undertakes that type of analysis, it's a net analysis, a net of any waste, community liens, any other potential claims or offsets that might be raised by the parties to get to a net figure. And that's what the trial court did in this case.
But the trial court didn't make any allowance for mortgage payments or any kind of a lien. And the issue certainly was raised that the estate or the daughters are entitled to a portion of that house. Is there an obligation on the part of the court to say we should do some sort of analysis to decide if there's a lien against the property?
I don't believe so. And first, I would disagree that the contention by the daughters that they had a claim to the house was expressly raised. I don't think it was as strongly raised as the paperwork
Wasn't
may
it pretty
seem.
clear, though, that they're saying Kathy's receipt of the house should be counted as part of her share? It seems like that squarely puts the issue out there that the house needs to be divvied up somehow.
I think, in all candor, that was more emphasized after the trial than during the trial. Honestly, our perception of the trial strategy for the daughters was this was never a violation of the preliminary injunction. Waste is not a legitimate consideration, and therefore not a lot of attention was placed on the house because they didn't think that the case would get to that point.
But let's say the house were the only asset in the estate, and it's $1 million house, and it's held in joint tenancy. Would we affirm a ruling that doesn't address whether the community has any, and let's say there's no indication that the down payment was made by Kathy's mother, there's no question that it's 100% community funds that were used to purchase, to pay the mortgage, to make capital improvements, and it's a $2 million home. We would say there's no problem in just having the entire residence and the value of the residence passed to the surviving spouse because of joint tenancy without any consideration of whether the community had a lien.
Sure, and I think that question broadly is, does the court on its own have an obligation to conduct that analysis if none of the parties raise it or if none of the evidence specifically addresses that? And I don't know if I can pronounce that obligation on the court in this case. I think the court, as a practical matter, trial courts have to litigate the cases that are brought before them. They rely on the parties to advance the theories that they believe are most successful for their clients. And if it's not brought to the court's attention, I don't think the court affirmatively has to do that.
Do you have any idea what the amount would be if there were a community lien?
I don't. I've not done that math. But I think in the end,
Well, until you came here today, were you anticipating questions regarding a community lien?
Not the community lien. No. Family law issues related to real estate, yes, but not the community lien. But again, I think that's consistent with our view that it has to be a net number. Whatever those calculations or offsets may be, depending on the facts of each situation, the court ought to consider those if they're brought to the court's attention. And in this case, they simply weren't.
As long as we're talking about equitable principles, let's talk about waste.
Yeah.
Normally in a family situation, the burden is to come forward with a prima facie case. But does that really work in a probate situation, since the decedent has no way of rebutting or refuting or even discussing or proving, well, they wouldn't be the decedent, but the estate?
Well, it certainly handicaps them, but I don't think that there is no way to prove it. And in fact, they have attempted to rebut that through their briefing by saying Ms. Carr lives in Las Vegas, he would come, he would visit, there's opportunities where he would pay for meals. They developed testimony where Kathy was aware that Frank gambled and she witnessed that. So I think there are ways to rebut that. But again, I think it was a trial strategy that waste is not an appropriate consideration, and so I don't think they wanted to develop that as a trial strategy because in their mind the court never should have reached that. But clearly it would handicap a litigant from trying to develop it. But I think there's ways to doing that, a forensic analysis of bank accounts, deposition of the surviving spouse on the types of activities. Although it's not a dissolution case, there could be evidence similar to an affidavit of financial information where a party's assets and expenses are disclosed, and opposing counsel can cross-examine a surviving spouse about those expenses and compare them with the alleged waste. So I think there is work that can be done to rebut that.
Well, in this case, but you had just expenditures from a bank account. I mean, and her testimony about I believe in one she said, I don't even know what that was for. How does that prove waste?
Well, I think that is the nature of waste, that it would be contrary to a claim of waste if the surviving spouse knew what the expenditure was for and willfully turned a blind eye towards that. I think that would be considered an acknowledgement of some extravagant expenditure of community funds and therefore not waste. So I think by definition there has to be a degree of ignorance of the type of expenditure. So her testimony, in our mind, is completely consistent with what a waste claim would look like. A spouse doesn't know about something and can't explain it and cannot point to any benefit that the community received at or around the time of the expenditure to show that the community benefited from that.
But the burden is on that spouse to show the waste, to prove the waste.
The surviving spouse.
Right.
Yes,
So
yes.
How does, I don't know what this was for, how does that meet their burden, I guess, is the better way to phrase that question.
Well, it has to be viewed in context with also the amount, the type of expenditure. If it's it has to be an abnormal or unusual type of expenditure. So when you have that type of threshold, I don't know what that's for, and you're talking about a significant amount or some kind of abnormal expenditure.
What was the amount here?
Pardon me?
What was the amount that you're talking about?
I think the
Was it
question was on a
$300?
$500.
But yeah, so $500. Are you saying that would establish waste if somebody spends $500 on an unexplained expenditure?
I think it can.
And also
And it did.
cannot. It depends on the finances of the parties. And in this
Absol-
situation, how does it?
Absolutely, it can and it cannot, and that's the purpose of the trial court, to view the parties and assess their credibility. Judge Corey listened to Kathy testify about their finances, their standard of living, and he credited her testimony that amount, unknown to her, was an abnormal expenditure that could not be accounted for some benefit for the community. So as a fact,
when we cross-reference that with the fact that she didn't have a debit card, never saw any of the finances, he controlled everything, is it her responsibility to educate herself, or does she get the benefit of remaining ignorant by not asserting any kind of dominion over her own destiny in this case?
Sure. I think that analysis is subsumed in the waste elements, that it has to be an abnormal expenditure, not any benefit for the community. I don't know if there's any comparative fault type of analysis or there's some kind of duty to explore your own finances and be aware of them. I think all of those fair considerations in everyday lives, and that we all hope in whatever marriages or relationships we're in the end, there are situations where there are waste. Of course, the legislature, the state has acknowledged that, and the courts have commonly upheld claims of waste where the spouse does not know what that's for. I think
Judge Curry's, he believed that gambling, if these expenditures were used for gambling, that would be waste?
he did, in part, yes.
Okay, well, isn't that just entertainment?
It can be.
Well, how is that waste?
It depends on the factual situations. For one individual, gambling can be entertaining. For another, it can be an addiction that's going to ruin a family. And we can have somewhere in between where it's a waste of community funds that do not serve the community at all. And so that's a highly factually intensive analysis that the trial court is in the best position to judge. And I think that's what he did here.
So if a spouse's entertainment is gambling, it's waste, but if he or she likes to take boat trips or whatever, that's not waste?
I think it crosses the line from entertainment to waste at some point. And it can apply to boating. I think if you boat once every 4 or 5 months or during the summer often, that's an entertainment. But if for some reason you're on the boat on Lake Pleasant for 4 hours every day of the year with no explanation,
Fishing.
that could be a waste.
So if he goes out to Lake Pleasant fishing 4 hours a day, every day as a retired individual and just enjoys it, but spends $20,000 a year doing that, that's waste?
It's not, but I thank you
Why,
for
what's the
bringing.
difference? If he spends $20,000 doing the same thing gambling, it's still $20,000 and it was both based on entertainment.
No, you changed the facts by saying he was retired and he had a boat, and so if the facts of the situation and if the facts of the parties established that the individual is retired and was in a position to spend that much time and money at the lake, considering the resources of the parties, the totality of the circumstances, then that may not be waste.
And how is that
But for
different
someone else, it
than-
may be waste.
Well, how's that different than, I believe your client, the decedent retired in 2014, and that's when the gambling increased. So he's retired, just like the fisherman was retired. How is this different?
It's different because of the parties' relationship, that they could not afford gambling. It was not something that they had agreed would be part of the family entertainment. And so, according to the facts of this case, the judge believed, Kathy, that was abnormal and excessive for their family. It's necessarily a sliding scale. Gambling $5,000 for me may be nothing to someone who gambles $25,000 a day, and that's waste for me, and it's not for him.
But characterizing entertainment, you're characterizing gambling as an addiction, as a
Hypothetically.
disease, as a this. But if we were to just consider this entertainment, if he had spent the exact same amount on a fishing trip, would that be wasteful? If wife had said, I don't want you doing that, I don't agree to this, and he did it anyway.
Well, I think it could be, except for the fact if wife knew about it and said, I don't agree with that. I think arguably that's a little bit more of a gray area. But if the wife didn't know about it and he did go on a fishing trip to Alaska or wherever, same amount of money, then that could be waste. I think the type of activity arguably could be waste regardless of the type of activity, even if it otherwise seems to be a wholesome type of activity. If it's abnormal and doesn't benefit the community, then it arguably is a waste case that the party has to prove for that particular family. Well, thank you, Your Honors. I appreciate the opportunity. I want to make clear we're not abandoning any of our claims. I think there was some argument in the briefs that we don't believe that the trial court appropriately ruled in this case, and we're not abandoning any of those claims of the position. It seems like I should just set aside the remainder of my prepared remarks because I think I've addressed the issues that the court is concerned, unless there's any other questions that you would have for me. I think in the end, the community property, the community asset necessarily is a net number. It's community property minus any liabilities. That's what we developed at trial. We think the judge correctly ruled on that, especially with the house. It's simply separate property that's not supposed to be part of that consideration.
All right, thank you, Mr.
Thank you.
Briggs. The matter is deemed submitted. We'll issue a decision in due course. We'll now prepare for the next argument.